This event is sponsored by Stuart Title, and I'm delighted to say once again that Stuart Title are so supportive of the legal profession in providing title indemnity products for use by residential conveyancers and commercial property lawyers, and to have appropriate members of staff with sufficient expertise to provide backup, both with regard to product knowledge, issues associated with risk relating to product, and also compliance. And in that regard, I'm delighted to say that we've got Freddie Ullman with us from Stuart Title. Freddie, good afternoon to you, and thank you for coming along. And I think you've got a few words to share in connection with the work that you do and the assistance that Stuart Title can provide in connection with title indemnity. Freddie.
Yes, hi, thank you, Ian. Welcome again to our June edition of the England and Wales Property Forum. It's another opportunity for you to really, ask as many questions as you can to Ian, and I'll obviously be here as well to, help behind the scenes with any sort of technical issues or any sort of insurance-related questions that I might be able to help with. We're growing at Stuart Title. We have just hired quite a few new underwriters, which we're hoping is going to make our response times even quicker and increase our pool of knowledge. So if you want to get in touch with any of them or want an introduction, please sort of talk to me, reach out to me, Robert Kelly, or pick up the phone with any of the details that are listed. And we would love to sort of, build that rapport with all of our underwriters who are ready to get going, because it's a busy time. We have a webinar this week with Ian Quayle and Ian Mitchell on parking issues that I've been told to mention. That's on Thursday. So that's another thing to sort of get your teeth into. But really, Ian, over to you. And thank you very much.
Thanks, Freddie. Yeah, as Freddie mentions, Stuart Title have been recruiting furiously. And again, as far as the underwriters and Freddie and the team are concerned, again, able to offer assistance with the questions or queries concerning product, and also able to provide training in connection with compliance. Remember, of course, that compliance training is a requirement with regard to any firm that's offering title indemnity insurance products. So Freddie and Robert and their colleagues are able to assist in that regard, as well as supporting the profession with regard to allowing me to do CPD training, as Freddie mentioned, something on car parking with Ian Mitchell, who's a KC who was involved in one or two of the most famous cases involving car parking. So that should be interesting on Thursday. Anyway, what I want to do now, Stuart Title's contact details on slide there. Robert for Scotland, there's Elizabeth. Freddie's contact details I've given you, and the business development team's general contact details again on slide. So, as always with these presentations, what I'd like to do is just share with you some useful resources. I always mention this. I'm speaking at a conference today, and I've just gone through this list. One of the things you may not be aware of is the City of London Law Society's Land Law Committee has now a precedent bank dealing with clauses that should be inserted in contracts, commercial or residential, where there are lease management issues. So residential lease management issues, commercial lease management issues. There's now wording that you can insert in a contract to ensure that the seller, who theoretically remains landlord pending registration of the buyer's title, to ensure that the seller does that which is necessary to protect the buyer's interests in connection with either residential leasehold management or commercial leasehold management issues. Again, I was mentioning this morning, property protocols and the boundary dispute protocol is really important, I think, for conveyancers, in that it assesses and highlights where boundary problems can arise, provides guidance as to dealing with neighbour disputes, and highlights the benefit of determined boundary applications and also formal boundary agreements. So that's always worth a look at. I mentioned the Leasehold Knowledge Partnership website, very important when you're dealing with leaseholders that have problems with landlords. And I mentioned Property Law UK, which is a monthly electronic publication that comes out towards the end of each month. The June edition will be published tomorrow. It is a subscription service. It is sponsored by Stuart's Title, and it contains a wealth of articles on all manner of different cases, both resi and commercial. So if anyone's interested in that, we can ensure that arrangements are given to you and details given to you, and I'm sure we can make available to you a free copy of one of the most latest editions, so you can see what it's all about. Anyway, topics for today that I would like to explore. There are a number. First of all, as ever, the Building Safety Act. There is a case called Bromfield Road that I've spoken to you about in the past. And the interesting thing about this case is that the First Tier Tribunal basically said, forget about the government guidance. When we're looking at determining whether a building is a higher risk building, we are of the view, the First Tier Tribunal, that a roof garden, is a story for the purposes of calculating whether a building is a higher risk building. The thinking behind that decision was that members of the public, tenants and leaseholders, could access the roof garden. And therefore, if there was a fire or if there was some other form of building safety issue relating to the building, the fact that leaseholders or others had access to the roof garden would mean it would be necessary for those parties to be evacuated in the event of an emergency. It followed, therefore, that building safety issues should be paramount and it should be deemed to be a higher risk building as a consequence. That runs against the government guidance, which said things like roof gardens were to be ignored as in calculating the number of stories for the purposes of either a higher risk building or a relevant building. So we had a degree of conflict between the First Tier Tribunal decision and government guidance. First Tier Tribunal in Blomfield said the government guidance is guidance, it's not law. It's not part of the Act of Parliament, it's not part of the Building Safety Act, nor is it part of the regulations. And therefore, its value is limited. And, said the First Tier Tribunal, we think that it's wrong. As a consequence of Bromfield, the government amended the government guidance and put a health warning at the beginning of it, saying, we're aware of a decision of the First Tier Tribunal that cast doubt on the legitimacy of the government guidance, but the government guidance continues to be important and the government guidance should be followed. We've now had an appeal in connection with Bromfield Road, enabling the upper tribunal to explore what the First Tier Tribunal did. And what we've seen is a retreat from the decision at the First Tier Tribunal. That retreat involves three elements. Element number one, First Tier Tribunal says, where we're dealing with a remediation order, we're not only going to ask you to remediate building safety defects, but we're going to tell you what that remediation requires. So we're going to give you a shopping list or a specification that you're going to have to deal with in order to comply with our order. Upper Tribunal said you can't do that. You can ask that defective works are remediated, but you can't say how they're to be remediated. You've gone beyond the scope of your jurisdiction in doing so. The second thing that the First Tier Tribunal said was, we're going to impose a time limit. So we're going to ask you to do all of this work by September 2025. And again, the Upper Tribunal said you've got no jurisdiction to deal with that either. On the issue of whether or not a roof garden constituted a story, the Upper Tribunal adopted a very interesting approach. What they said was this: what you've done, First Tier Tribunal, is given an opinion relating to whether or not the roof garden constitutes a story for the purposes of calculating whether a building is a higher risk building. That you were dealing with had nothing to do with being asked about that decision. And secondly, your finding carries no weight. So it was a matter of opinion. The Upper Tribunal said, therefore, the government guidance must be followed and not what was held at first tier level. So in short, what we've got now is a decision of the Upper Tribunal that says a roof garden is not a story for the purposes of determining whether a building is a higher risk building. There's a number of things you can extract from that. Firstly, all first-tier tribunal decisions are not binding, so they are very limited authority, and they're not precedent. They are potentially persuasive at best. The next thing that's important to extract from the case is that as far as being asked to interpret the Building Safety Act, there is need for interpretation. As we've mentioned on a number of occasions in the past, it's not a good piece of legislation. The regulations aren't particularly helpful, and the government guidance is to an extent not particularly helpful either. And therefore, we're left very much as we have been left with in the past, with bad legislation that's difficult to advise upon. The first-tier tribunal has attempted, Lena being the obvious case, but Bromfield Road another one, to try and assist practitioners, and I think that assistance hasn't thus far worked. So, interesting case, you need to be aware of it and just be aware that the upper tribunal has sort of clarified that position. The next thing with regard to BSA questions is, in the last week, I have attended, I think it's 6 conferences, and speaking at 6 conferences. And in doing so, I've been bombarded with a number of Building Safety Act questions. Those questions can be divided into 3 areas. Area number 1, and landlord certificate. Question: can you compel a landlord to provide a landlord certificate as far as the conveyancing process is concerned? And the answer to that, I'm pleased to say, is an emphatic no. You cannot compel a landlord to produce a landlord certificate. There was a case that went to first-tier tribunal where the first-tier tribunal specified the Act and the regulations do not facilitate opportunity for any interested party to compel a landlord to produce a landlord certificate. The next point with regard to that is, if a landlord is required to produce a landlord certificate, in other words, if a trigger event occurs, what's the consequence of the landlord failing to provide it within the 4-week period? Well, there are a few points. Firstly, a landlord cannot extend the 4-week period. He can't say, I can't produce it in 4 weeks, but I can produce it in 6 weeks. The second point is that if a landlord should produce a landlord certificate but fails to do so, that will not preclude the landlord from issuing a new landlord certificate if a new trigger point arrives or occurs. A new trigger point might be leaseholder indicating an intention to sell, or a leaseholder requesting a landlord certificate, or a landlord wanting to transmit remediation costs for relevant defect into service charge. So a landlord can always issue a new landlord certificate where a trigger point occurs. The fact that the landlord has failed to produce it in connection with the current trigger point is not fatal. The next point with regard to landlord certificates is, what's the purpose of a landlord certificate? The purpose of a landlord certificate is for the landlord to disclose to the seller, or indeed a buyer, A, the landlord's status or the former landlord's status as of the 14th of February 2022, and B, the landlord's knowledge with regard to relevant defects in the building to which the certificate relates. The financial circumstances of the landlord as of the 14th of February 2022 is important to enable seller and buyer to determine whether the landlord meets or fails to meet the contribution condition. Remember, if the contribution condition is met, the landlord is required to use its own resources to cover remediation costs and can't transmit those costs into the service charge of qualifying leaseholders. Whereas if the contribution condition isn't met, the landlord can transmit its costs to leaseholders, but in those circumstances, the leaseholders may still be protected, courtesy of Schedule 8 of the Building Safety Act. And as far as the information concerning state and condition of the building is concerned, that is important because, 1, unless a landlord discloses the existence of the problem, the landlord will not be able to recover the costs associated with remediation of relevant defects it's aware of as against qualifying leaseholders. So, 2 issues to the landlord certificate: 1, financial information; 2, construction and building safety information, both of which are going to be of interest to a prospective buyer and may impact on the buyer's decision whether or not to proceed or not. If a landlord produces information in a landlord certificate that is incorrect, A, the landlord could be liable for misrepresentation, and B, the landlord could also commit an offence under Section 2 of the Fraud Act 2006. The next issue with regard to landlord certificates is to what extent, if I'm a residential conveyancer, should be advising the seller or buyer about the content of the landlord certificate. And here again, I can be quite equivocal. It is absolutely essential that a lawyer acting on behalf of a seller or buyer advises their client that they cannot give advice unless you are comfortable in doing so. And I'd have to say I've yet to encounter a residential conveyancer that was comfortable in giving advice. So that's landlord certificates. The next issue is leaseholder deeds of certificate. And again, I'm really interested about leaseholder deeds of certificate and the confusion that still arises with regard to a certificate. Firstly, despite the Law Society guidance, despite the wording of the leaseholder deed of certificate itself, I repeat the point, it is not necessary for a leaseholder to voluntarily provide to a landlord the leaseholder deed of certificate. The leaseholder deed of certificate is essential for a buyer because it discloses whether or not the lease is a qualifying lease or non-qualifying lease, provided, of course, the information in the leaseholder deed of certificate is correct. But it doesn't have to be voluntarily provided to a landlord. The next point that I think is important here is only if a landlord requests a leaseholder deed of certificate does it have to be served on the landlord. 2 points here. One, a landlord can request a leaseholder deed of certificate if within 5 days of receiving notification of an intention to sell, a request is made. So the landlord has a window of opportunity for requesting a leaseholder deed of certificate. If that request is made within that time frame, the leaseholder must provide it within 8 weeks, which can be extended up to 12 weeks. It was thought that if a leaseholder failed to produce it within that 8-week or 12-week window, the lease was then permanently non-qualifying. That position is not correct. I repeat, not correct. The lease is deemed to be non-qualifying, but it is non-qualifying until a leaseholder serves a leaseholder deed of certificate that states the lease that is qualifying. Now, there's some confusion here. If you look at the regulations impose quite a regime on a landlord where a landlord has requested a leaseholder deed of certificate to remind the leaseholder, I'm still waiting for it. Why would the regulations compel a landlord to take prescribed steps and reasonable steps with regard to the request for a leaseholder deed of certificate within the 8-week period or 12-week period if at the end of the day it didn't matter? I haven't got an answer to the questions that arise from that problem. But I repeat, a landlord can insist on a leaseholder deed of certificate. If the leaseholder provides it within 8 weeks or 12 weeks and states the lease is qualifying, then it's qualifying automatically. If the leaseholder doesn't provide it within that time frame, it is deemed to be non-qualifying, but the position can be remedied by a leaseholder deed of certificate being served thereafter. Other issues with regard to leaseholder deeds of certificate: is it necessary for a buyer to see a deed of certificate from the leaseholder? The answer to that question is yes. Whether the lease is qualifying or non-qualifying, the leaseholder deed of certificate should be produced and the buyer's solicitor should advise on the content. In connection with advising on content, you can't advise with certainty that the building is a relevant building, nor can you advise with certainty the status of the producer of the certificate as of the 14th of February 2022. Now, Zara, have you seen the Grenfell documentary on Netflix? Zara, I haven't. You're saying it's worth a watch. I have seen a documentary about the parent company of the French company that produced the cladding, and the fact that the American company and its board was aware of the problem with regard to the cladding and aware of the cladding being sold and utilised on the Grenfell building. So Zara, I haven't, But yeah, I mean, the Grenfell story, the Grenfell inquiry, is tragic, isn't it? Both as to consequence and also the inability of organisations at all levels and in connection with all matters failing. The one thing I would say about the Grenfell inquiry report that I would ask practitioners to be aware of is this. In the report, the inquiry suggested to government that determining higher risk buildings purely and simply on the basis of height or number of stories was obviously arbitrary, but obviously unwise. The reason that it's unwise is that you could have a building that's significantly lower than 18 meters or 7 stories, but which is occupied by persons that, due to ill health or infirmity, are unable to evacuate within 10 minutes. On the other hand, you could have a 24-story tower block occupied by bright, fit and healthy young things that could evacuate very easily within 10 minutes. And therefore, the definition of a higher risk building should not be determined by height or stories, and that it would be better if the determination arose in connection with a number of factors, including who's in occupation or who are leaseholders. Now, again, whilst the sentiment behind that proposal I endorse completely, it worries me. Because if we're saying the status of a higher risk building depends on who's in occupation, we've got a nightmare from a management perspective. So if we've got 3 leaseholders in our buildings who are 30-somethings and fit and healthy, but then who move out and who let their flats to elderly and infirm relatives, then potentially we have a building that was not higher risk that becomes higher risk as soon as those persons occupy. Now, I repeat the point that this is a recommendation in the Grenfell inquiry report, and as yet I haven't seen any appetite on the part of the current government to give effect to legislation or regulation that addresses that issue. Zara, anything else in the Netflix documentary that you want to share with us? Well, Zara, I know you've said in the past about issues with regard to fire engines in London being unable to evacuate buildings, etc., and compartmentalization issues arising. Could a Grenfell happen again? My guess is it could.
Ian,
yes, sorry, Zara.
Just to chip in there, there was a fire before Grenfell, which was shown in the documentary,
right.
And the coroner at that inquest had warned the government that it would happen again.
Yeah.
So it's not an isolated incident.
No,
the government were aware of this.
Yeah.
We as conveyancers, we can't. We have no knowledge about construction practices.
Yes.
And design of the building, and we're happily being given certificates to say yes, these buildings are safe. And so from all my investigations, we're happily being given EWS1s or documents saying building safe, all good to go. I'm saying to people who don't want to listen to me is that you might be buying on the 8th floor, you might be on the 4th floor. If if you're a little old lady relying on the lift, it's not just about a fire. It's about the management of the building. How are you going to get in and out if you suddenly become disabled and that lift stops working?
Yes, of course.
How are you going to get out of the building if it is stay put? And as the Grenfell documentary showed, they were all told to stay put.
Yes.
Which is, some people did try and help themselves to get out and put together bed sheets, but they ended up, deceased. People who are designing buildings need to have a bit more thought to this, but this is outside of a conveyancer's control.
Absolutely.
This is outside of a conveyancer's scope of practice, and we just need somebody to put together some common sense steps to sort of say, look after yourselves and do some simple things to keep yourself safe. But you cannot, what other people do is outside of your control.
Absolutely. Zara, you make some excellent points. There's a few things really flowing on from that I want to share with you. One, and this is horrible, right? But let's just park the morality issue for a moment or two, and let's look at it purely and simply in the sort of cold light of conveyancing practice. You need to say to clients, I am not an expert with regard to fire safety. I am not an expert with regard to assessing risk, with regard to the ability or otherwise of evacuating this building within a suitable time frame. Again, I'm not required to explain to you the risks associated with mobility issues in connection with your acquisition of a high-rise flat or an apartment. So I think you need to do that. I also think you need to say to clients, look, it could be the Building Safety Act is subject to amendment. It could be the status of buildings change as the law develops. It could be that, notwithstanding, as Zara mentions, the EWS1 or other information concerning surveys concerning fire safety risks or building safety risks, the information in that documentation could be incorrect, and you could be living in a potential inferno that is a risk to life and limb. I can't advise or explain other than to highlight the existence of risk. That's the first point. Second point about, Zara says, well, there should be some sort of general information for clients highlighting these issues. I wholeheartedly agree. It may be that you could, in an information sheet to clients, explain some of these sort of practical issues, like Zara just alluded to, for clients so that they are aware of it. Is there likely to be anything that could help clients? Well, there's two things. I haven't seen anything from the Leasehold Advisory Service that is a sort of a practice information sheet for clients, other than explaining what the law is. I haven't seen that, nor have I seen anything from the Leasehold Knowledge Partnership. My guess is the Leasehold Knowledge Partnership is going to be more likely to produce that information than the Leasehold Advisory Service. But I'll ask the Leasehold Advisory Services if there's anything in the pipeline in that connection. And the other thing that I think is important to understand is where a building is building more than 18 meters, more than 7 stories in height, there are issues associated with the responsibility of the landlord to do some of the things that Zara was mentioning there. Assessing risk. I know that, Zara. Yeah. In assessing risk, not just risk generally, but risk in connection with particular leaseholders. So a landlord in a higher risk building is required to have evacuation policies and to keep those policies under review depending on who's in occupation or who are leaseholders. So certainly in connection with higher risk buildings, I think some of those issues are being or should be undertaken by the landlord or the accountable or principal accountable person, depending on the building. And again, when we see the building safety regulator properly financed and properly resourced, we should be seeing the building safety regulator taking on some of the issues that Zara just mentioned. But at the moment, I don't think the building safety regulator has resources to do anything. I stand to be corrected, but I haven't heard anything other than the building safety regulator dealing with spats between landlords and former landlords concerning remediation orders and remediation contribution orders. My guess is, as time goes by, there will be more proactive or more active in connection with what I would class and what Zara was touching on there, proper building safety management that has real results. Okay, Zara mentioned something else, new builds. Some of these are not being registered with the building safety regulator, nor any provisions being written into contracts or leases. And watch out for the EWS1, the name of dissolved developers. Yeah, well, EWS1s always come with a health warning, Zara. Remember, a building that's more than 18 meters in height should be registered with the building safety regulator as a higher risk building. And if it's a new build or renovation or alteration, there is an obligation that before anyone goes into occupation, the building safety regulator is served with a completion certificate. A criminal offence is committed if a residential occupant goes into occupation without a completion certificate being issued and served on the building safety regulator. Okay, The next thing I want to talk about are boundary issues. And again, in my travels up and down the countryside in the last week or so, lots of questions arising in connection with boundary and boundary problems. And again, here I can divide the questions and the issues into three distinct areas. Number one, the basics. Don't give a client a title plan without the warning that the title plan can't be relied upon to identify legal boundaries. Number two, make sure clients understand the problem that we have as residential conveyancers or commercial property lawyers in legal boundary identification. It's almost a difficult, if not impossible, task, given that a boundary is a pencil line separating one registered title to another. Next point, when dealing with unregistered land, remember that first registration, will flush out boundary disputes potentially, but won't fix legal boundaries. So make sure in your retainer and in your information to clients generally, make sure that clients are provided with appropriate information and have realistic client expectation. Right, so with regard to boundaries, set realistic client expectation, give a warning with regard to title plans, check client objective for boundary sensitivity, check the transaction for boundary sensitivity. Where you need to know where a legal boundary sits, there are three things that can be done. Where you're creating a new boundary, you could refer to national grid coordinates in the contract or transfer, and in doing that, you're going to be less reliant on any plan that's produced ancillary to the document. Where there are existing boundaries, so we're not creating a new boundary, but we're looking at existing boundaries, a few things. One, these days, I would be recommending the use of a formal boundary agreement. The relevant practice guide, which is practice guide 40, I think in Annex A, has wording for a formal boundary agreement. The Land Registry will note a formal boundary agreement on relevant registered titles, and there's been a recent decision that confirms that formal boundary agreement is binding on the parties, but also binding on subsequent owners. In the past, there was some dispute about that. I think it's the Court of Appeal that looked at this issue and said that what we've got is a demarcation agreement. And as such, that agreement is binding on the parties to the agreement and subsequent owners. So I think there's two or three things to extract from that. One, if I'm creating a formal boundary agreement, I would call it a demarcation agreement. And two, I would lodge it at the Land Registry. I would also make sure that any plan accompanying the demarcation agreement is of sufficiently larger scale to enable the boundary to be identified, or again, utilize national grid coordinates. Speaking at a conference last week where a practitioner had dealt with a transaction where national grid coordinates were used to identify a building plot, and he said that ensured precision with regard to boundary identification. The next point that I want to make concerns determined boundary applications. And given what I've said about formal boundary agreements, I think we're going to see a decline in the number of determined boundary applications being made to the Land Registry. A determined boundary application is to the Land Registry made by a title owner asking the Land Registry to fix the legal boundary between that title and an adjoining title. The actual process envisages the neighbouring landowner consenting or objecting to the application. Can I say, I think it would be rather unwise to make a determined boundary application to the Land Registry that you knew was going to be contested. The reason why I would say that is unwise is because the Land Registry is likely to refer that matter to first-tier tribunal for determination. Where, however, I might say a contested application would not preclude my making a determined boundary application would be in circumstances where I was concerned that my neighbour could potentially claim adverse possession for the land that was bordering the boundary that is now being determined. Because a determined boundary application will stop the clock ticking with regard to such an application. But determined boundary applications, A, need a plan that is Land Registry compliant, which invariably will involve the instruction of a chartered land surveyor, and normally will require the agreement of the adjoining landowner. So without a willingness to pay for a proper plan, and without the availability of consent from an adjoining landowner, I think we've got a problem. And therefore I would maintain that a determined boundary application is probably less likely and less advantageous, given that we've now had clarification confirming formal boundary agreements. So can I ask everyone that's present today, one, do you all, when setting a title plan to a client, warn the client they can't rely upon it? Two, do you explain to clients in setting realistic client expectation that it is difficult, if not impossible, to identify legal boundaries? Three, in circumstances where there is boundary sensitivity, offer the client the options of formal boundary agreement or determined boundary application. Now let's put this into the context of a residential conveyancing transaction. I'm acting for a client. The client is worried about the northern boundary to the property. A number of things we could do from a practical perspective. Number one, put a special condition in the contract requiring the seller to prove the location of that boundary. Two, compel the seller to enter into a formal boundary agreement with the adjoining landowner, which is a demarcation agreement which fixes the boundary between the two properties. Or three, make a determined boundary application with the collaboration of the adjoining landowner. I think if we do one of those three things, we're going to ensure that our client is buying a property without buying risk associated with litigation. Where a client does not embark on any of those three routes, where the client is not advised about those three routes, there is a danger that the client buys the property and then encounters a problem where the intentions relating to the boundary are to be exercised. Where we have an uncooperative or hostile neighbour, we could quickly and easily see how litigation could ensue. So I think we need to be careful about boundary issues and boundary sensitivity issues. And that applies with regard to the boundaries to the property that is being acquired or disposed of. But I think also it is an issue with regard to things like accessing rights of way or shared driveways and repair and maintenance issues, etc. All sorts of things can arise. Zoe, thank you, Zoe. We say in our property reports, the extent of which is outlined in red on the title plan. Plan has been surveyed on a small scale. The red boundary line is not intended to identify the precise location. Good. Please compare the boundaries outlined in the plan with the physical boundaries of the property on site. Advise us immediately if you find any discrepancy so we can clarify with the seller. As your property lawyers, we've not visited the property, therefore we can't advise. Zoe, that is absolutely excellent. Thank you for sharing that with everyone today. One or two points to note there. I would say that the Land Registration Act states that we can't rely on a title plan because it reveals a general boundary, not a legal boundary. I think a great point that you make is that the client should be invited to, when they inspect the property, to check what they see when they inspect is consistent with the plan. The only gloss I would put on what you've said there, Zoe, is I'd also refer to the client to how the property is described in the contract and how the property is described in the property register, and ask the client to confirm, whether or not when they inspect there is anything that would reveal or potentially challenge how the property is described, as well as the plan. And the other point, Zoe, that I might adopt in that situation is to give the client a copy of the estate agent's particulars, and again say, is there anything on inspection that's inconsistent with those particulars? But Zoe, and thank you for sharing that. I think that's a brilliant sort of explanation in practice of some of the points that I've just made. Anyone got anything else to add with regards to that? Yeah, again, Zara, it happens all the time, doesn't it? Yeah, Google Maps is useful. Important, as Zoe was saying, to make sure clients are aware that we won't be inspecting. Freddie, many inquiries for title indemnity insurance with regard to imprecision relating to boundaries and any product available to assist. Don't know if you could turn your microphone on and help, Freddie.
Yes, sort of adverse possession cover is certainly something that we provide. We don't do it on a change of use basis, but a continued use basis. is something that we can certainly look at. You can go online and start there with a standard inquiry, or ring an underwriter and get a bespoke one, and they'll look at it.
Thank you. That's great. Thanks very much for that, Freddie. Thank you. Yeah, again, important. And I mean, the other thing is setting realistic client expectation. I think that is so critical with regard to our retainer, so clients understand the problems that we've got. And again, as Zoe was mentioning, one of the things is we won't be visiting the property. Zara, with regard to the use of Google Maps, I agree, really useful and really helpful. Again, a useful tool to provide the client with a photograph of the map and asking the client to confirm, is this consistent with what you saw, and useful for you checking how the property is described or how it's revealed on a plan. The other thing that I think is important on this topic before we move and talk about something else is to make sure that documentation and plans are consistent with one another. So again, sometimes you'll see a property being more particularly defined by reference to a plan than the plan being described as for identification purposes only. There's quite a bit of case law on that, to be honest with you. What the court will do in a situation such as that is ignore both, have a look at the property and determine which, as between the plan or the description, makes the most sense, having inspected the property. Okay, the next thing I want to talk about are service charge issues in leasehold transactions. And a few things really. First of all, yesterday I was asked an interesting question by someone. They were contemplating extending their lease, and they were saying that they were now having second thoughts about extending the lease, given the fact that they'd heard that common hold was being launched, and therefore leaseholds were likely to be extinguished. And can I say to that, one, yes, common hold is in the pipeline, but I wouldn't be advising a client not to extend a lease, not to contemplate enfranchisement or a right to manage, or indeed anything else, on the basis that common hold is just round the corner. Common hold is just round the corner. What I think is that the government will, in its new legislation, which we're expected to see in Q4 of this year, state that on new build schemes, all new builds, as of, my guess is 2027, will be common hold. I can't see this government, or indeed any future government, anytime soon, requiring all existing leasehold flats and apartments or buildings or developments to be converted into common hold. I don't see it. And the reason I don't see it is A, I don't think there's an appetite for it. B, I think the amount of work involved would just clog up the system, prevent sales and all that goes with it. What I think might happen is we have new builds, common hold for new builds introduced, perhaps 2027, and then certain types of scenario triggering conversion to common hold. Insolvency of landlord. Landlord relying on government grants for building safety purposes. Leaseholders contemplating enfranchisement. Leaseholders contemplating right to manage application. A sort of shopping list of events that would trigger the conversion to common hold. But I don't think currently any government would even contemplate the eradication of leasehold and the introduction of common hold in one fell swoop. I just don't think that would work at all. Okay, next thing with regard to service charge. Some basic practical points. Where you're dealing with a new build, or where you're dealing with an assignment of an existing residential lease and service charge accounts are produced, you need to tell clients the historical service charge account or estimated service charge account is not an indicator as to what service charge could be going forward. I think you also need to explain to leaseholders the statutory protection that's afforded to leaseholders, courtesy of the Landlord and Tenant Act 1985. The next thing that I think is important relating to service charge is that when looking at a lease, you are comfortable that the lease lists all the services that the landlord is obliged to produce and also enables the landlord to recover all the costs with regard to the provision of those services. Be very wary of sweeping up clauses. Any clauses of sort of general application relating to good leasehold management or recovery of costs associated with leasehold management. They are potentially all unenforceable. What we really need to see is a service charge regime, estimated accounts beginning, final accounts at the end of the year, ADR for dispute resolution, service charge being paid by leaseholders in advance, service charge being recovery of cost for the provision of services as per the lease. Nothing in the lease that is contrary to the fact that service charge monies are held in trust in favour of leaseholders to be utilised for the purposes prescribed by the lease. I like to see reserve and sinking funds being used or created in order to ensure that leaseholders have some protection where unusual items of outlay are likely to be incurred by a landlord, thus ensuring that leaseholders are not required to pay in the current service charge year costs in connection with expenses that will generate benefits for leaseholders going forward. Zara makes an interesting point. Leases don't tend to include clauses for improvement when maintaining and repairing. The landlord won't put in CCTV. I would agree, Zara. There is a more defensive position to mention with regard to that, and that is this. If a lease enables a landlord to improve and also enables a landlord to transmit the costs relating to improvement into service charge, that potentially could be disadvantageous. And a major disadvantage with regard to a landlord being entitled to improve is where a landlord can charge management fees as a percentage of service charge costs. I've actually seen this in operation to the detriment of leaseholders. Landlord entitled to carry out improvements, landlord entitled to a management fee as a percentage, I think it's 15% of all service charge costs. So landlord could repair or could carry out improvement. Repair, £4,000 cost. Improve, £20,000 cost. Management fee, 15% of that cost. Landlord likely to go for the expensive option on the basis of doing so, generating a greater management fee. So I agree with your point, Zara, always worth looking. And I mean, there's a wider issue there as well with regard to repairing obligations. In most leases, the landlord is obliged to repair structure and common parts, but can transmit cost into service charge. If the landlord is doing that, again, if the landlord can charge management fees as a percentage of that cost, considerable repairs and considerable repair costs will lead to a significant increase in management fees. As a general rule, I don't like management fees being assessed as a percentage of service charge cost. I like the landlord being entitled to recover a reasonable management fee or some form of structure relating to management fees in that regard. Anyone got any other issues relating to service charge? So warn clients, historical service charge accounts or estimated accounts are not indicators of service charge going forward. A blanket statement that I think is really useful when advising clients about service charge, a contractual commitment for the leaseholder to pay unascertained and unascertainable future expense in the future going forward. And we cannot and are unable to assess or determine what that service charge cost will be going forward. An interesting question put to me yesterday. What is the position if the service charge is a fixed sum? This is a really interesting question. If a service charge is a fixed service charge, then be careful because it's not a service charge as defined by the Landlord and Tenant Act 1985. That has consequences in connection with the Building Safety Act and also has consequences in connection with the 85 Act requiring service charge to be reasonable. Both don't apply where you have a fixed service charge. Zara makes a point. Our lenders now taking a stance as to how much service charge are acceptable according to property value. Shared ownership leases with a £6,000 a year charge are not sellable. So Zara, is that a marketability issue? And I don't know what a lender's stance is or a valuer's stance is with regard to high service charge costs in those circumstances. Yeah, I mean, but the problem with service charge, you see, is I go back to that point I made earlier, Zara. contractual obligation to pay unascertained and unascertainable future expense, cost of living crisis, buildings being allocated status of higher risk buildings with all the additional responsibility and burdens attaching to that, automatically racking up higher service charge costs. It's just, human nature. The idea of common hold is, in theory, to try and reduce service charge costs, because with a common hold scheme, leaseholders become unit holders owning freehold flats, and they become members of a common hold association. And the idea behind the common hold association is that there's a reduction in management fees and costs, and an incentive on the directors of a common hold association to keep the common hold assessment or service charge low, and in doing so, generating benefit for unit holders. The problem with the current government's revision of common hold is that we're likely to see professional directors being appointed as directors of common hold associations and professional directors charging fees for their services. And in those circumstances, we may be translating from a landlord who's being nasty and charging huge sums for service charge to a common hold association doing the same thing. As I mentioned to you earlier, with regard to common hold, the Building Safety Act issues and conundrums do not disappear into the ether. All you have is, instead of having a landlord who's liable for relevant defects in relevant buildings or higher risk buildings, you have a common hold association that becomes responsible for those costs. Okay, does anyone else have any questions for today? Any issues for today? What are people doing with regard to SDLT? Anyone seeking specialist advice, and anyone dealing with companies that are providing specialist advice with regard to SDLT? Meanwhile, Zara says, anyone else have clients that just don't care when you warn them about a blank checkbook for landlord and management companies? Yeah, Zara, they don't care, do they, until they get the massive bill. And then when they get a massive bill, they start pointing the finger at you. So that's where we need to be very robust with regards to our retainer and our report on title, warning clients about the potential liability that can arise in these types of situations. Sean Randall, yeah, I think they are trying to update the guidance for shared ownership. There is a company called Compass, I don't know if anyone's heard of them, and a company called Foursquare. I've just been talking to Compass this morning, and I've asked if they'd like to come along to a forum, and I think they would, to talk about SDLT issues. Remember, with regard to SDLT, two things. One, you should be always enabling a colleague to look at your SDLT calculations and decisions. Amy, use Compass. Happy, Amy? Certainly, I've heard good reports. But technically, I think it's CQS require you to have someone else have a look at your SDLT calculations and decisions. Bell Howley Peroton, don't know them, Laura. Impressed, Laura? Interesting. Yeah, okay, interesting. There's nothing wrong with your seeking specialist advice with regard to SDLT issues, point number one. And point number two, important, you should always have someone look at what you're saying relating to SDLT. And importantly, when you're dealing with SDLT, always make a note on your file how you've arrived at a particular decision. In other words, show your workings out. So that if HMRC come and have a look at your file at some point in the future, if you've made a mistake, they can see how you've made it. Has anyone had an HMRC inspection with regard to SDLT? I've never encountered it. Anyone ever have? Theoretically, they can go back indefinitely, can't they, if they suspect fraud? So I think Zara's asking there, Amy, whether or not you have to just retype everything into the system. Do what you like. All right, that's a bit of a cavalier attitude, Zara. I know shared ownership can be a problem. Mixed-use properties can be a problem too, can't it? But yeah, in your retainer, you should be saying that you'll give general advice relating to SDLT, but might require specialist advice depending on circumstances. Also with the SDLT, remember, you should be saying to clients, I'm relying on information that you're generating. Does anyone require a first-time buyer to sign a letter verifying their status? You are under an obligation to give general advice, and you are required to be aware of surcharges and reliefs that may be available. You also need to understand that the online HMRC calculator isn't necessarily accurate. Okay, anyone else got any other questions or issues before we finish today? Warn clients about the fact that incorrect information provided to you could mean that improper advice is given relating to surcharges and reliefs, and explain to the client that submitting a return on the basis of information that they have produced. So yeah, purchase questionnaire is useful. Zoe, hi Zoe, stamp duty authorization form to be completed. Yeah, all of that makes perfect sense. Anyone ever had a situation where additional returns are required? So, for example, overage payments. So again, be careful with your retainer in your report on title, because the retainer could be at an end, but there may be a need for the submission of an additional return where overage is paid at some point in the future, or some form of linked transaction. Do watch out and be careful with that. Any other questions or queries? Well, once again, that's been really, really interesting. I'm going to get Compass to come along to a forum. What do you do when selling a semi-or building with Alpha as the building warranty provider? How do we sell? Interesting one. Martin, the obvious thing, can you get anyone else to provide a warranty? Yeah, and I think you've got to be careful about clients relying on structural warranties generally. Anyone else help? Perhaps we'll have a look at building warranty providers next time. I'm going to take a photograph of that and make sure that we look at that next time, if that's all right with you, is it? We shall do that. Take a picture of that and we'll use that on our next topic. And I think we're just about finished for today, aren't we? Anyone else got any questions or queries? Okay, well, ladies and gentlemen, all I can do is thank you very much indeed for attending today. No problem. Debbie, glad you enjoyed it. Do mention it to your friends and colleagues. It is a free resource provided by Stuart Title with my limited involvement. Thank you all for coming along. Lovely to see some familiar names. Thank you for your participation. A few things just before we finish. Property Law UK out tomorrow. Anyone interested in that, let me know. We've done a deal with Sweet and Maxwell with regard to books and discounts relating to books. If anyone's interested, let me know. And we'll see you soon. Thanks, everyone. Stay safe and speak soon. Thank you. Bye-bye.